Now let's see what liquidated damages is. Liquidated damages is a common law term. It means that the parties agree on a sum to be paid if any of the parties fails to fulfill their obligation in a contract. It also means that the concept of liquidated damages applies, and in this case the defaulting party must pay this sum. They must pay the entire amount preset as liquidated damages without assessing what the actual amount of the damages was. It also means, of course, that the preset amount of liquidated damages is payable, also in the case if the damages exceed the amount of preset liquidated damages. Now, this is a point of law that you need to be aware of, compare it with the rules applicable to your jurisdiction, and use the term liquidated damages accordingly. In the event your laws allow the payment of damages in excess of the amount preset in the contract, then it's in fact not liquidated damages, but it's something else. Now, what else? What word can we come up with? Some international law firms that operate in similar jurisdictions use the word penalty. Sometimes they even call it contractual penalty. How about this term? It sounds good. It's perfect. It perfectly describes the purpose, which is basically penalizing the defaulting party for non-fulfillment of their obligations. But there is only one thing that you shouldn't forget about it. Penalty is unenforceable in the common law. It is something that the court will not assess if such a contract is brought before them. Then what is the conclusion? What can we do? Use the term liquidated damages depending on the situation, depending on the one hand the context, secondly the applicable law, and take into consideration what the intent of the parties was.